Good afternoon. Happy Saturday. I am going to be recording a video or maybe a live stream. I'm not sure exactly. It's going to be one of the two. It's going to be with Platoon hard drive this afternoon. I am going to be drinking during it, so that will be fun. And who doesn't love getting drunk in the day? I certainly don't. Anyway, I've been accused of falling asleep on the latest motion, the latest filing, the supplemental complaint, and that's not true. There's two things going on here. Number one, the law doesn't move very fast, and so I'm not in a huge hurry to cover these things. And number two, I take great joy in listening to other commentators who have no idea what they're looking at or why they're looking at it, but I love to listen to them struggle to explain why and how Chile fucked up. And I've yet to hear anyone do it, so I'm sure someone has, but whatever. I will go ahead and we'll go through the motion for leave to supplement first amended complaint, and then the actual supplemental complaint. And they're attached. Boom. I thought he attached his supplemental complaint. There it is. There's the supplemental complaint. And yada boom. So he had his supplemental complaint attached to it. So it's not a big surprise when it actually ended up getting filed. So here we go. Motion for leave to supplement first amended complaint. Pursuant to Federal Rule of Civil Procedure 15D, plaintiff Jose Chile Decastro respectfully moves this honorable court for leave to file plaintiff's supplemental complaint. See attachment 1, supplemental complaint. So he has attached it. It shouldn't have been any surprise to anybody that that's what he was going to end up filing when the court granted this motion. I provided the proposed supplemental complaint to counsel for defendants and conferred via email. Defendants do not oppose adding YouTube as a defendant, but they will require more time to answer the first amended complaint, which I have not yet stipulated to. Now, I want to pause everybody there and remember the email that Garrick sent. The email, or excuse me, the filing that Garrick did. Let's It was this one right here. He's asking for, this is what Garrick sent, asking for extended time to file responses to plaintiff's first amended complaint. As grounds for the motion, plaintiff has indicated that it will file a second amended complaint. A second amended complaint. Now here Chile is saying that, they'll require more time to answer the first amended complaint if I do my supplemental complaint. That should have been a clue for Chile, but I've been enjoying this too much, watching this particular shit show come crashing to a burning halt. So, So anyway, that should have been a hint. But we're going to get into the argument here. Courts may permit supplemental pleading setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. That's Federal Rule of Civil Procedure 15D. This is Federal Rule of Civil Procedure 15. Here is D, supplemental pleadings on motion and reasonable notice. Court may, on just terms, permit a party to serve a supplemental pleading setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. The court may permit supplementation even though the original pleading is defective in stating a claim or defense. The court may order that the opposing party plead to the supplemental pleading within a specified time. So that's that. The First Circuit has recognized that courts customarily have treated requests to supplement under Rule 15D liberally. Indeed, they have. This liberality is reminiscent of the way in which courts have treated requests to amend under Rule 15A's leave to freely given standard. Indeed, that is true. Rule 15D is intended to give district courts broad discretion, allowing supplemental pleadings as a tool of judicial economy and convenience, and its use is therefore favored. Indeed, it is. Here, plaintiff filed his first amended complaint on November 16, 2022, document 62 in the record. After using the FAC for some counter notifications under the DMCA, YouTube revealed their behavior that broke their safe harbor protections under the DMCA and also made decisions to leave content infringing on plaintiff's copyright on the YouTube platform, making YouTube partially liable for any further damages after their processing of the DMCA notice. Plaintiff could not have known that YouTube would have behaved in this tortious manner until after his first amended complaint. I have also published content since the date of the first amended complaint that has been infringed. No factors exist that would support denial of plaintiff's motion. Plaintiffs have not unreasonably delayed in attempting to supplement. This motion comes less than 2 weeks after the facts arose, with a holiday during that time. The supplemental pleading will not unduly prejudice the defendants and will help prevent them from having to countersue for several liability of YouTube. I don't know what that means, but okay. No responsive pleadings have yet been filed, and all parties were on notice of this potential supplementation through conferring over email. Plaintiff's supplemental claim is not futile. Plaintiffs have pleaded allegations which, if taken as true as they must be at this state a claim for which the court can grant relief. An amendment is not deemed futile as long as a proposed amended complaint sets forth a general scenario which, if proven, would entitle the plaintiff to relief against the defendant on some cognizable theory. Conclusion. Since supplementation will aid in the speedy and effective resolution of this case, I respectfully request the court grant my motion for leave to file my supplemental complaint. Signed, certificate of service and everything, and then you have the supplemental complaint. It's titled Supplemental Complaint. Obviously, it must be a supplemental complaint. So those other darn two attorneys, what was it, Garrick and Wish, they didn't know what they were talking about when they were saying anything about second amended complaint, right? So here we go. Here's his supplemental complaint. So he had to attach us to the motion. And I mentioned back when I talked about this that I didn't go over his supplemental complaint. I said he has to actually file the complaint that he had attached to his motion. That's what he got granted leave to file. So he can't change it. This is what the court said. You can file this thing that's called a supplemental complaint. Well, let's skip ahead a little bit, shall we? So after he filed that, the court said, plaintiff's motion to file a second amended complaint, and defendant's motion for an extension of time to answer the forthcoming second amended complaint are both granted. Now, again, you're saying to yourself, this says supplemental complaint, and she's saying second amended complaint. You remember the two attorneys, they said, plaintiff wants to file a second amended complaint. And Chili's like, no, I'm filing a supplemental complaint because my legal expert, Mark, aka Delete Laws, says that I get to file a supplemental complaint. Unfortunately, adding a party is an amended. If you add a party, it's an amended complaint. You have amended the complaint to add YouTube. Sorry, not sorry. And I want to point out, a complaint can be both amended and supplemental at the same time. I.e., if you add a party and plead facts, circumstances, occurrences that happened after the previous complaint had been filed, that would be both a amended complaint and a supplemental complaint, but for our intents and purposes, it is a second amended complaint. That's why the court ruled the way it ruled. That's why the two attorneys were talking about, hey, he wants to file a second amended complaint. But Chili's stupid and uneducated, and Mark is also stupid and uneducated, and they didn't realize it. They didn't pick it up. They didn't read carefully. Nothing caused them to start thinking, oh no, maybe I'm effing myself in the a-hole. But they did. They effed themselves in the a-hole. So let's look at the supplemental complaint. This is the operative second amended complaint. The first amended complaint is gone. It's done. This is, despite the title, this is the second amended complaint. These are all of the facts and allegations and causes of action that Chili currently has pending on the table. I want to make that clear. This is it, kids. Pursuant to Federal Rule of Civil Procedure 15D, plaintiff Jose Decastro hereby files this supplemental complaint to its first amended complaint in connection with its federal claim of copyright infringement, adding YouTube and its unidentified employees making copyright determination, as defendants for events that have occurred since the filing of the First Amendment complaint. Further, plaintiff supplements facts and copyrighted works and alleges as follows. Again, this is a Second Amendment complaint, despite his introduction there. Number 1, since the filing of the First Amendment complaint, YouTube and unidentified individuals at YouTube have made determinations outside of the DMCA notice and takedown system, giving up their safe harbor protection under the DMCA and causing plaintiff harm by interfering with his ability to exercise his copyright. Number 2, defendants YouTube and individuals at YouTube, John Does 1 through 20, are severally liable for damages relating to plaintiff's First Amendment complaint against the remaining defendants. Jurisdiction and venue, don't really care about. Parties, well, now the only parties are Decastro, YouTube, and Does. These are the parties now. Ruby Rack. Factual background. I have published over 800 videos, to which I own the valid copyright to, as content to my YouTube channel. Defendant YouTube publishers have copied my content without consent. Defendant YouTube has specified their DMCA designated agent as Copyright Operations, YouTube, LLC, 901 Cherry Avenue, San Bruno. So all of a sudden now you're in the wrong district here, buddy, because there are no defendants that are actually in here listed as parties to which you have a claim against in here that are in Massachusetts. This is a dumpster fire that I don't know what's going to happen to it. I don't know, but it's bad for Chile right now. Sorry. Upon receiving notices of copyright infringement to the agent at paragraph 11 by plaintiff under 17 U.S.C. 512c3, YouTube and John Does 1 through 20 have failed to take down any infringing content on their service. YouTube and John Does 1 through 20 have determined on multiple occasions that content is exempt from takedown under the DMCA due to copyright fair use, not even considering that I notified them that I had filed a court action in violation of the DMCA and its standard technical measures. Defendants YouTube and John Does, and now you can't just say, I have filed a lawsuit. You actually have to show them, the pleading. You know what Kate did when Kate lied about having filed a copyright lawsuit against Aiden? She provided a case caption with a header and with case number on it to show that she had in fact filed a copyright action against Aiden. That's what Chile has to do. He's just not smart enough to know it. And it has to actually say that it's against that particular defendant, the person that you've issued the takedown against. Defendants YouTube and John Does 1 through 20 do not accept notice of a filed court action to defeat a counter notice under the DMCA standard technical measures, but instead require a court-stamped copy of the full lawsuit. So it would be this document right here, and you can see up at the top there is going to be the stamp. I mean, that's so their attorneys can pull it up through Pacer, verify that it is what it is, and then then they know that you've actually filed the lawsuit. They're not just going to take you at your word, you dummy. And if they pull up this, they're going to see only a few names. They're going to on this, they're going to see Josh Abrams, Kate Peter, John Does 1 through 50. Now they're going to see YouTube and John Does 1 through 20. That's really weird. It should be like Rose, ROES, instead of Does, or they have a few other different variation of Doe, but you don't use Does 1 through 50 and then Does 1 through 20. That's just going to get confusing. Anyway, but yeah, they're gonna look for actual confirmation because they're on the hook if they don't restore somebody's work if you haven't filed. So yeah, you have to actually prove to them that they filed. You're just not smart enough to understand it. Defendants refuse to answer what they mean by court stamped, whether it's a received stamp, which isn't relevant to e-file documents, which all federal courts use, or whether they mean a certified copy, both of which are more than the requirements of the DMCA standard technical measures. Yeah, if you just gave them like this page that has this number up here, then they'll probably be able to figure it out. YouTube does not have a policy that is consistently enforced for the termination of repeat infringers under these things. How do you know that? That's quite the allegation there, son. My works are listed in Exhibit 1 of the FAC, and the ones added since the FAC listed in Exhibit 1 of the supplemental complaint by YouTube URL, Certificate of Service, and Certification of Local Rules. Now, these are the only videos currently under the new amended complaint that are at issue. So there you go. There you go. So that's the problem. He screwed himself. He's dumb. He's wrong. I don't know how he's going to fix it. I don't know if he's even going to figure out that he needs to fix it, although apparently Discussing Laws watches my videos, so he'll be able to figure out from what I've said how badly he screwed the pooch on this. And I'm just going to say this, like, Mark, you have no fucking idea what you're doing, dude. You may be having fun, and that's great, but you have no fucking idea what you're doing. You are literally just... You're drowning, you're thrashing around, but it's not helping you. You're not getting any closer to the surface. All your thrashing is doing is just sinking you deeper and deeper. So stop, dude, stop. Anyway, thanks for watching. Have a great day.